Welcome to another edition of the Plan Well podcast, hosted by owner and attorney of Cary Estate Planning, Paul Yokobitis.
Hey everybody, it's Paul Yokobitis back with another episode. I believe this is episode 7 of the Plan Well podcast. And today we are touching on the topic of the PPP, or the Payroll Protection Program, and the newly passed law that is entitled the Payroll Protection Program Flexibility Act, or PPPFA, which was signed into law on June 5th. We're speaking about it today, June 9th, 2020, because it creates some very different rules to play by for any businesses that took part in and received PPP funds, how they can be administered, timelines, specifics, those sorts of things. So just to jump right into it, the biggest change or the most significant when it comes to easing restrictions on small business owners who participated in the PPP program is certainly to extend the time period that business owners had to use those funds from 8 weeks to 24 weeks. So the original PPP statutory rules, the regulations on point, the interim rules from the Treasury Department, SBA, required that the small business owners that received loan proceeds would have to use those proceeds on business expenses within 8 weeks of the date the money was funded. So as soon as the money hit your bank account, you had 8 weeks to utilize those funds for payroll and related business expenses like rent and utilities and interest. And so that essentially gave business owners 8 weeks to spend what was supposed to be 10 weeks of payroll funds on things like payroll. And so you may think, wow, that's pretty ridiculous, because how can you spend 10 weeks of payroll in 8 weeks? Well, they allowed or the original version of the rule, as we mentioned in the first podcast on this topic, which I believe was episode 2, required that at least 75% of the loan proceeds would be used for payroll costs. That could be salary, could be commissions, could be bonuses that were in the regular course. Expected bonuses certainly shouldn't be made up bonuses or irregular bonuses, that kind of thing. But it allowed for the other 25% to be used on things like rent, utilities, and interest, and things like that. And so that at least made good on the 10 weeks of payroll being spent in 8 weeks. So first and foremost, changed the 8-week period to 24 weeks. So now some people are funding these sorts of expenses until nearly the end of the year. Which is great for people who are trying to get their ducks in a row and organize their expenses before they actually set forth on a plan of attack on how to use these funds. I'm not sure 24 weeks was really needed. Probably 12 to 16 would have been appropriate for most businesses, but you generally don't complain about those sorts of provisions that are put in place for everybody's benefit. So now, so that was the first change. It went from 8 weeks to 24 weeks. And then certainly at that point, you would make, a loan forgiveness application to, set forth the basis for forgiveness, that you use those funds for the appropriate expenses within the 24-week period. And certainly if you still use those funds in the 8-week period, you're not going to be penalized for doing that. Certainly you still complied with the original rules. And obviously the original rules are less restrictive than the new rules. So complying with them as they were originally set out, still in good standing as it sits today. The second significant change is that the amount of the loan needed for payroll was lowered from 75% to 60%, which then grew the amount used for things like mortgage payments, rent, utilities, loan interest from 25% to 40%. But it looks to be that the 60% is somewhat of what they would call a cliff. So if you, in previous versions, If you use less than 75% of the loan on payroll, then you'd have basically a pro rata reduction on the amount that could be forgiven based on the amount under 75% used on payroll. It looks to be in these new rules that if you don't reach the 60% threshold, then the entire loan is unforgivable. So it's a somewhat of a difference in practical effect if you're not able to comply with that portion of the law, but it certainly gives a lot more flexibility for the types of expenses like rent. If you have an expensive lease, you can certainly use those sorts of funds for more, or those sorts of expenses can utilize more of the funds than payroll themselves. So it went from 75-25 payroll to miscellaneous expenses to 60-40, which is great. Third rule change is that the Flexibility Act pushes back the June 30 deadline to rehire workers to the end of the year, December 31st, 2020. And so, I think the goal there is to, again, give some more flexibility for business owners to, rebuild their team in an orderly fashion instead of feeling rushed to bring people back into the fold, especially if there's the uncertainty of what the fall looks like and potentially a second wave of coronavirus infections and shutdown and those sort of things. So it can allow business owners to be a little bit more practical and intentional in their rehiring practices because they'll certainly just have more time to do so. You certainly wouldn't want to force business owners into a position that makes them more financially unstable just to comply with the payroll protection program. And so third change, again, is delaying the deadline to rehire workers from July 30th to December 31st, 2020. Another is going to be that to the extent the loan is not forgiven, the original language of the payroll protection program allowed for any unforgiven balance of the loan to be turned into, or basically, resulting in essentially a 2-year 1% interest loan. The Payroll Protection Program Flexibility Act changes that from 2 years to 5 years. So whatever balance remaining that isn't forgiven is a 1% loan on a 5-year amortization, which gives obviously a heck of a lot of flexibility for repayment, and obviously doesn't make business owners rush to make cash available to make loan payments. Of course, these sorts of rules are always subject to shifting around and those sorts of things, but there's always some uncertainty, surrounding the Treasury and SBA rulemaking process, interim rules, final rules. There's always potential for another round of congressional revisions. Certainly, if we have another round of COVID infections and another round of shutdowns, we're likely to see more significant legislative action on the part of the legislature. And so these sorts of provisions are always subject to change, hopefully for the better, not for the worse. The last change that was made was essentially easing the rehiring requirements under the Payroll Protection Program. So this new version makes two pretty significant changes. First, it extends the rehire date. Obviously, we mentioned that earlier, to December 31st, and then it actually adds additional exceptions for a reduced headcount. So the law now states, I want to quote it, that a business can still receive forgiveness on payroll amounts if it is unable to rehire an individual who is an employee of the eligible recipient on or before February 15, 2020, is able to demonstrate an inability to hire similarly qualified employees on or before December 31, 2020, or is able to demonstrate an inability to return to the same level of business activity as such business was operating at prior to February 15, 2020. The lack of clarity in that, though, is how you would have to demonstrate the inability to rehire or demonstrate the inability to return to previous levels of business activity. But this is where we hope that these government agencies would give guidance. Certainly the IRS, the Treasury Department, and the SBA, we would hope are going to be giving additional guidance on what that would look like. But it says, it's generally the good news is that even with a reduced headcount based on these exemptions or exceptions rather, if 60% of the loan is used for payroll through the end of 2020, then the entire loan would be forgiven as long as the other 40% is used for appropriate expenses. So lots of additional flexibility certainly shifts the dynamic a little bit. Certainly for a lot of business owners, we were coming up on the 8-week deadline. A lot of businesses were funded in April or May, so their 8 weeks would come up in June or July. And so with these changes in the regulations and the actual rules surrounding repayment and forgiveness, certainly a lot more businesses theoretically should qualify for forgiveness, which is great. That being said, no one is exempt from audit. It looks like there was initial SBA guidance that basically anybody who received a loan under $2 million was basically going to have a safe harbor. That's a little bit more up in the air now, as to whether the loan was necessary, whether the loan, was needed because of a lack of access to credit elsewhere. So it's always going to be prudent if you're a business owner that participated in the PPP program that you keep robust records, complete records. Obviously, to the extent you receive PPP funds and you utilize a payroll service provider, you may want to hold those funds in a second account and redirect payroll just so that you can have a clean statement. Certainly, we use a program called Gusto for our payroll, and they already compiled or they make it really easy to compile PPP reports to basically account for payroll payments, when they were made, to who they were made, those sorts of things. So additionally, you may work with a CPA or a bookkeeper or a lawyer to work through what is forgivable and what isn't, what's the appropriate evidence to set forth in the forgiveness application, and those sorts of things. Obviously, you still just want to be very prudent and complete in your record keeping and your decisions on what to do with this money. Never misuse it, right? There's already been criminal charges on people who have, committed fraud in the submission of loan documents or have used funds. I know there was a rapper who was arrested for using funds for, basically lifestyle purchases. Obviously not the intention of these loan programs. So keeping that in mind, use it for what it's for. Obviously the incentive of forgiveness is directed at ensuring that. If you've got specific questions, it's always a great idea to speak with your lender first and foremost, to see how they're going to review and process forgiveness applications and what sort of documentation and supporting statements and reports they're going to want, so that you can get those ready. Certainly, if you're making lease payments, you should have your lease ready. If you're utilizing it for that 60% payroll, then you should be running payroll reports that are going to divide from like reimbursements and contractors and things that are not, forgivable, as opposed to W-2 employee, salaries, benefits like insurance and 401k and those sort of things. So obviously keep your records, keep them separate from your normal business operating records, and obviously file on time, right? 8 weeks to 24 weeks is a big jump. So I think a lot of business owners, the risk is that you'll become complacent. And then, the longer you take to file for forgiveness, the less likely you'll have complete and accurate records. So whenever you use the funds, go ahead and apply. As long as your bank is accepting those forgiveness applications, it's appropriate to submit them as soon as reasonably practical, just to make sure that all your ducks are in order. So it's nothing you have to worry about at the end of the year when you're otherwise planning for taxes and those sorts of things. All business owners, good luck in this process. Good luck in resuming normal operations now that we're beginning reopening. And we wish you the best. This is Paul from Cary Estate Planning with episode 7 of the Plan Well podcast.
That's it for this week's episode. Make sure you like, subscribe, and share. We'll see you all next time.